Enforcement hearing for the City of North Miami. Today is, what are we? March 5th, 2014. I am Beatrice Cazo, Special Magistrate for the City of North Miami. The purpose of the hearing is to determine if a code violation exists at your property as observed and cited by a code enforcement officer of the city. If the city is not able to prove its case, then I will dismiss the case and you may leave. These proceedings are being recorded, therefore all persons who are speaking should do so one at a time to ensure that all testimony is clearly audible on the recording device. If English is not your primary language, then please inform me when I call your case. We have a translator who will assist you during the proceedings. When your case is called, the property owner, agent for the property owner, and any witness that you may have should come forward to the podium on the left side of the room. When asked, please speak directly into the microphone and say aloud your name, your business or mailing address, and your relationship to the property. If you are not the property owner or an attorney representing the property owner, then you must present a notarized power of attorney affidavit in order for your testimony to be taken on behalf of the property owner. For new cases, you will be asked for the record if you are aware of and understand the violation that is being heard today, and do you understand what is required to resolve the violation. Please answer accordingly. The city will present its case first, and then the property owner or violator will be given an opportunity to testify on their own behalf, to bring forward witnesses to testify, to present evidence and photographs, and to cross-examine the city's witnesses. Following the case presentation, I will issue a finding of fact on the case. If I find that a violation of city code exists or existed at your property, then depending on the case type, I will set an abatement date for the violation to be resolved. And for repeat violations, I will impose a daily fine amount. For new, non-repeat cases, my order will include an abatement date by which you must resolve the violation, and a daily fine amount that I may impose at a future hearing date should the violation not be resolved by the abatement date. If I find sufficient cause to postpone enforcement action at this time, I will table this case proceeding to another hearing date in the future. If you do not agree with my finding of fact and/or ruling, then the property owner may appeal the administrative order on the case to the circuit court. An appeal must be filed within 30 days of the date of the execution of the administrative order to be appealed. In accordance with Florida statutes, if a person decides to appeal any decision made by the special magistrate with respect to any matter considered at these proceedings, then the person will need a verbatim record of the proceeding. This record includes the testimony and evidence upon which the appeal is to be based. The cost of obtaining the verbatim record shall be the sole responsibility of the appellant, and it is recommended that persons who plan to appeal their case should provide their own court reporter at this proceedings. Pursuant to city codes, if the City of North Miami prevails in prosecuting a case before the special magistrate, the city shall be entitled to recover all costs incurred in prosecuting the case. The current cost assessment amount is $100 per case. Once the city records an order that imposes a fine and authorizes a lien against the property, then the city will charge additional administrative fees to record and release the lien. Now, if you are giving testimony today, please rise and raise your right hand while the officer issues the oath.
Do you swear and affirm that the testimony that you're about to give is the truth of this proceedings and the whole truth and nothing but the truth? If so, please say I do. Please join me in the pledge of allegiance to the flag. I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Please be seated and turn your cell phones off or you put them on silent, please.
I think some people have just walked in. If they can come forward and sign in. If If you just walk in, you can come forward and sign in. And if we can call the first case. Oh, I'm sorry. Are there any deletions, or any amendments to the hearing agenda?
Yes. Number 1, Angel Martinez, CEBMP 2013-00017 was postponed to April hearing. Number 2, Ann Ellis, CEODS 2013-00114 is complied. Number 4, Blanca Garcia, CEOSV 2013-00064 complied. Number 5, Charles Wells, CESEA 2013-00001 complied. Number 6, Cindy James, CEBMP 2013-00100 complied. Number 7, CLP 4700 Northwest 15th Court LLC. Case number CMHS 2014-00004 complied. Number 8, Dazelle Nims, CEODS 2014-00013 complied. Number 9, Emma. Hello? Emma Capital Management, CEBMP 2013-00133 complied. Number 10, Francisco Rodriguez, CEODS 2014-00017 complied. Number 11, Frederica and Karina Matthews, CEBMP 2013-00130 postponed to April. Number 14, Jacqueline Zulian, CEBMP 2013-00127 complied. Number 15, James Frevlis, CEODS 2014-00021 complied. Number 16, John F. Jelk, CEBMP 2013-00033 was postponed to April. Number 17, George Fandora, CEBLR 2014-00008 complied. Number 19, Kathleen Britton, CEODS 2014-00008 complied. Number 20, Marceline Pierre, CEEXP 2013-00185 complied. Number 21, Mark A. Walker, CEBNP 2013-00073 was postponed to April. Number 22, Nancy Laria, CEBNP 2014-00002 complied. Number 24, Rachel Reeves, CEEXP 2014-00030 complied. Number 29, Samuel Mathurin, CEIBY 2014-00029 was postponed to May. And that concludes all amendments and deletions to the agenda.
Thank you. We may call the first case.
The first case, George Fandora, case number CEMIS 2014-00001, and Alan Graham is the officer.
What page? What are we?
Number 18.
Sir, if you can go over to that podium, please.
Sorry.
Good evening.
Good evening.
Can you state your full name for the record, please?
My name is George Fandora. My address is 2035 Keystone Boulevard, North Miami, 33181.
All right.
Good evening, Your Honor. Alan Graham, North Miami Police Department Code Enforcement Officer. I have been sworn. Your Honor, we're here tonight on a case cited for the property owner to renew a storage pod permit or to remove the pod from the property. On January 21st, 2014, I inspected the property at 2035 Keystone Boulevard. Review of the Dade County property records indicated that the property is owned by George Louis Fandora and Iniet Suarez, and the property was purchased by the property owners on February 2013. The property has a storage pod on the property. It has been there for a while. I took a photograph yesterday on March 4th depicting the house and the storage pod as it's located on the east side of the house. I'd like to introduce this in evidence by first showing it to Mr. Fandora.
Thank you.
City code is clear that under land development regulations, you're required to have a permit in order to have a storage pod. I reviewed the property records for the property. At one point, there was a permit for a storage pod that was issued to Maria Arjana, and that pod permit was issued in May of 2011. There is no current pod permit, and I obtained this information by a review of the permit history for the property. And I would like to introduce that also into evidence at this time.
Sure.
Your Honor, I'd like to direct your attention to page 2 of that permit history, and if you will go down on the left-hand side to you see an entry marked ZPOD.
Yes.
That is the last time that a pod permit was issued to the property.
And that's the one dated for May
That's the one, May
2011?
2011, to Miss
Maria.
Yes, Arjana,
Okay.
who is not the current property owner. So under this circumstance, I did have an opportunity to drop off a permit application to the property. As of yesterday, when I looked at the permit history, I did not see that the permit application had been received by the city. And therefore, I'm bringing the case forward at this time for an explanation of why the permit for the pod hasn't been submitted to the city, or why the pod is still on the property at this time. And that concludes my testimony on this case.
And let me just inquire, if a permit was issued or has been issued in the past, would it be difficult for it to get renewed?
No.
Okay. All right, sir.
Yes, ma'am.
You heard the testimony of,
I did.
okay.
This was all based on some real unfortunate circumstances. About 9 months ago, my son and my nephew were perpetrated in an attempted robbery. My nephew was killed. My son was 190 days in the hospital. As soon as he issued the violation, I came and I spoke to him. He gave me an explanation. I said to him that I had gone to the city that day prior to speaking with him, trying to obtain a permit. They told me that as long as I had open construction permits, I did not need a pod permit. He later came back to me and instructed me that he had spoken to somebody over there, and they said that that was not right. He gave me the pod application. I went back to the city the following day, as I told him that I would, and I tried to apply for a pod permit. The lady told me again, she said, you have 3 or 4 pending open construction permits. You do not need a pod permit. 2 days later, my son relapsed from his gunshot wound, and he's been in critical condition. I haven't had the time. I'm here today just trying to get this issue done. He goes by my house quite a bit because I get the papers. And he'll be able to tell you that my truck is never parked in front of my house. I'm never home. I mean, I've been, like I said, I was 198 days in the hospital. The permit's $29. That's not a money thing. It's a time issue thing. The last thing in my life right now is worrying about a pod permit. I could care less about that pod permit. My nephew died. My son is in real bad condition again with a collapsed lung. I explained this to him. I didn't know that people could be so cold to say the word, it might sound cruel, to continue to proceed such a senseless violation under the circumstances that there is. I think family is first. Like I said, I could really care less. I have like 4 or 5 open permits for construction that have probably been expired. Nothing, and I explained this to the gentleman when I spoke to him. There hasn't been a stitch of work done on my house since this happened. You know, I don't know what I can tell you. I have not had the time after taking 2 days to come down here and spend 3 hours down there trying to get a permit. I haven't had the time to leave my son's bedside. And I'm really sorry. If I'm in violation and I have to pay, it's not a problem. Money's really insignificant when you deal with a situation, because I've learned that life can change for you in 2 seconds. And I'm not asking for any pity. I'm speaking to you from the heart, the way I feel. The $29 that the permit cost, my time is worth infinite. That's all I have to say. I don't.
The city attorney wanted to add something.
Yes, sir. How much time do you think you would need? I'm so sorry to hear about your tragic circumstances, but how much time would you need to resolve this?
I've tried, like I said, I've tried to go down there to get a
He's
permit.
receiving conflicting information. So let me ask Mr. Mr. Graham. He's been there twice, and they're indicating to him that the fact that he has what is it?
Open
construction
permits. There's no pod permit
that he
needed.
doesn't need to get a pod permit. So
That is incorrect. The Land Development Code, the way it is written, does not provide for any exemptions for construction.
but apparently somebody that's at that office is giving out conflicting information to the residents.
And this has been going on for years now because of the tremendous turnover of personnel in the building department who have no clue of what the land development regulations are, or even some of the city codes. There's now a new group in there that was hired under contract with the city to do permit intake and inspections. And unfortunately, these people have not been properly trained.
Okay, but
the
unfortunately,
land development regulation is crystal clear on what is required. And all they have to do is look it up.
Right. Unfortunately, it's unfair to have this residence, keep going back and forth between you and whomever the other person with authority to issue the permit, considering everything that he's going through to his family. It's not fair.
And I agree, and I sympathize with him and his family under the circumstances. It is not my
No,
my
I'm not
intent
blaming
to,
you. I'm
to
absolutely not. I want to make the record clear that I'm not blaming Mr. Graham. He knows what the city requires. Unfortunately, it's not fair to you. And based on that, I think the city attorney had asked, how long would you need? Is it possible, Alan, for him to meet with you and for you to help him with this? Because I don't think it makes a difference if we tell him, if we give him 30 days or if we give him 60 days, if when he goes down there to obtain the permit, the person says that you don't need it.
I'm sorry to interrupt you, and I understand what you're saying. I was also cited for not having numbers on my house. I have a picture on my phone. In front of my house, I have a tree that when I bought the house has 2035 Keystone Boulevard. When I went down there, I said to the young lady about the numbers. She said, but you have the numbers, long as the numbers are on the property. So, I finally went and had somebody put the numbers up. They really don't know what's going on down there. And they get pretty ticked off when you ask the same question. I did it 2 days in a row, and then I said, you know what? I'm done with this. Whatever happens, happens, because like I said, I was staying down at the hospital. It wasn't like I was coming back to North Miami. I've been at JMH for all these days. I think if you can give me 45 days, I'm going to try to get the permit, because I don't know what's going to happen if my permits have even lapsed and I'm going to need that longer. It's just, it would be unfair for me to tell you,
Okay, so let's table this. He wants 45 days. Let's table this till, what are we in, March, April? May. Let's bring this back in May.
I appreciate it.
And Your Honor, I'd be glad to assist Mr. Fundora any way as possible. If he could bring me the completed application and just the check, I would process it for him and then deliver the permit to him.
They said that they needed a,
Right here.
something for the property, and it's not a
survey,
It's not a survey. It was something else, a layout of where it was or something, and asked. That's what the other inspector gentleman told me, because the lady that I spoke to, she happens to be one of the supervisors there. It's the
I will be glad to offer my services again to Mr. Fundora. All I need is a signed application, and I can take care of, and basically everything else that they need. Just the signed application and a check made out to the city of North Miami, and I'll be glad to fill in the amount if they'll trust me to do that.
What time are you in the office tomorrow? I'll be at your office first thing in the morning, because I'm here for
I start work tomorrow at 9:30.
I will be at your office tomorrow at 9:30.
All right, so hopefully this will be worked out, and if it does, I guess you won't have to be back here. Thank you,
very
sir, and
much.
good luck to you and your
Thank you
son.
very much, and I'm sorry, like I said, I wasn't asking, I wasn't doing this under pity. It's just the reality and the ugly facts of what
Of
my
life.
life has gone through lately.
Absolutely.
Thank you, and God bless.
Thank you, sir.
Thank you, Your Honor.
Next.
Item number 27, Realty Services, Officer Vita Lynn Christie, case number CEODS 2014-00020.
Good evening.
Good evening, sir.
My name is Barry Gamble. My address is 13499 Biscayne Boulevard, Unit 1708.
And what is your relationship to this property?
I am the owner.
Okay.
Vita Lynn Christie, Code Compliance. This is a new case in regards to outdoor storage at the property. The property is currently being rented. I met with the property owner last year because she had quite a bit of items out on the front porch and in the side yard and in the backyard. She did clean up a bit. I did post the property with a courtesy letter on the 15th of January. We did mail out notice to appear, and I do have pictures of the current property earlier, and as of 2 o'clock, I did see them moving things around. I don't know what the state is as of 5, but as of 2, I have a few pictures.
Okay.
Okay, that is correct. I've spoken with the tenant, Mimi, a few times about it. She said she removed one truckload worth today and is supposed to have the truck come back tomorrow for another load. My tenant ships a lot of stuff to her family in Haiti, and it being a two-bedroom house, she doesn't have a lot of space inside to store everything before she ships it out. But even the previous time I got your courtesy letter, and I immediately called her and told her we need to clean this up right now. This is a problem. And again, I actually received this letter Friday afternoon in the mail, and I called her immediately to say, we have an issue here. And she told me she would take care of it that day. Of course, it wasn't taken care of that day.
Mm-hmm.
But she has, like you said, started to move some things, and we're trying to get everything cleaned up immediately.
Oh, I'm sorry. So the pictures that you've showed me is as of 2 o'clock this afternoon?
Pretty much.
Okay, so we still have a lot of stuff that needs to be
She
removed.
still has quite a bit of items on the front porch and in the side yard remaining.
She's making an effort, however, it's still
It's not
a
enough.
lot of stuff there. It's not enough.
If I could ask for a week to get everything cleaned up, if it were up to me personally, I would have a dumpster there first thing in the morning, have everything thrown into the dumpster and hauled away. Of course, that's not legal because it's not my belongings. If she needs assistance to throw it out, I would be happy to send a dumpster there for her to throw it out. again, she's trying to save all these things to send back to her family in Haiti. Again, she has started to clean some of it up, and
Let me ask the code enforcement officer if she has any objection. Do you have any objection to us giving her,
Well, I'm pretty sure by the abatement date, which is, I don't have an abatement date, probably a week or so from now if he's just asking for,
It would be-
and we don't have another hearing until next month, the first Wednesday, so that should be sufficient time for the property to be cleaned up.
all right, so what the officer is asking me is for me to make a ruling and find that the violation does exist. Basically, I find, based on the testimony of the code enforcement officer, that the violation does exist, and that I can give her an abatement date of, where's my list? April 1st, 2014, which would give her plenty of time to get rid of everything that's currently there. In the event that she does not, she will start accumulating penalties
okay,
And
that
at
should
the
be more
rate-
than sufficient.
at a rate of $25 per day.
Okay.
And you'll be surprised how quickly that adds up. Okay? And maybe you shouldn't tell her that she has a month to get it done. Maybe you should tell her
No.
she has by the end of the week, or,
I'm going to tell her she has 7 days as of tonight, and the code enforcement officer comes by on a daily basis to check on progress.
correct?
And
And let
I
her
don't
know
know if
that you'll
it's-
pass on the cost to her.
that's what I've already told her. And actually, Friday she started yelling at me on the phone that she can't believe it. And I said, well, Mimi, we've been through this a year ago. You know it can't keep stuff there.
Right.
It has to be clean. And it is what it is. You need to clean it up. And that's the end of the story.
Or pay up.
Yeah.
Okay.
The end
all
of the
right.
day.
All right, sir. Thank you.
Thank you
Okay.
very much.
All
Have a
right.
good evening.
You too. I'm ready.
Item number 30, Timothy Lazarus, Officer Shanna Sanders, case number CEEXP 2013-00177.
Good evening, sir.
Good evening, Timothy Lazarus, 12030 Northwest 8th Avenue.
All right.
Shanna Sanders, City of North Miami Code Compliance Officer. This is a case for a report of previous compliance in regards to the exterior of the property. Upon inspection today about 4:15, the property is in the same condition, but I do see that he has obtained the building permit.
Okay.
If you would like to see updated pictures to give you a recollection of what the violation is about, I do have them if you would like to see.
Yes, please. Okay, I remember this. All right, so he has obtained the permit.
Yes, I see as of Monday, the 3rd, he obtained the permit.
Okay, and if I can remember correctly, and let me make sure I get this word correctly this time around, it's stuccoed, right?
Stucco,
Okay,
correct.
so it needs to be stuccoed.
Yes.
Is that what the permit is for?
It's for wire lath, which has to be applied first. Inspection called for the wire lath so they could check it. Once they pass the wire lath inspection, then the stucco will be applied.
Okay,
Then there's another probably inspection for that scratch coat.
all right.
I guess if he can give us a time frame. I guess the permit is good for 6 months, but how long it will take for the property to be brought into compliance?
Right.
I would say less than a month.
Okay, well, we like that. So, so if I give you a date to comply by April 1st, 2014, that shouldn't be an issue.
No.
Okay, but you do understand what the code enforcement officer is asking. right? For the entire job to be completed within 30 days.
I could say I could do the job in 30 days easy, but it's up to the city whether they pass it the first time I put the wire lath. I don't have control of the inspector.
Okay. So do you want to bring it back for a report in 30 days?
It's totally up to you.
That would be better. I mean, I can show progress, and you can see the progress.
All right. Let's come back in 30 days and see how far along we are. Okay?
Yes, ma'am.
All right. Let's reset for 30 days. All right, sir. Thank you. Do
Thank
the
you very
best you
much.
can.
Yes, ma'am.
Okay? If it's the city's holding everything back, then you won't have to worry about, me
I don't-
setting up a lien or, penalty fees or anything like that.
I don't think they will. I mean, it's pretty simple.
Okay, so like I said, so long as the city's end, that's not, that's
Right.
not doing what they need to do, then you will not have a fine.
Correct.
So go ahead and do what needs to be done.
Okay, ma'am.
We'll see you in 30 days.
Thank you.
Thank you, sir. Ready.
Item number 12, Gerald Uribe, Officer Graham, case number CELDR 2014-00002.
Good evening, sir.
Yes, good evening. My name is Gerald Uribe. My address is 12490 Croton Road.
Okay. Who's the officer, Brian?
Yes.
Again, Alan Graham for the city, North Miami Police Department Code Enforcement. I have been sworn. Your Honor, this case is related to violation of Chapter 29 Land Development Regulations for a house being painted without first obtaining a permit on February 4th, 2014. I inspected the property at 12490 Croton Road. Property is owned by Gerald M. Uribe. Ownership determined by a review of the Dade County property records, and the property was purchased on June 2008. And I do have the record if you need to review it. I cited the property for the house being painted without first obtaining a paint permit. I had received a complaint from two sources that there's a house on Croton Road that had painted an orange color. And I reviewed the city's records on the permit browse to look to see if there was a paint permit issued for the house, and I found none. I'd like to submit an array of 4 photographs and the permit browse history into evidence.
That's my house.
It's pretty orange, all right. I was just about to wonder why anybody would want to call in and complain about somebody painting their property if it's to beautify the community, but it's pretty orange.
Now, if you look at the permit history, if a permit was issued, it would be issued by the building department. On the top, it would be B. It would start with B, and it would either, I don't know if they do PAI for paint. I don't, but there is nothing there indicating that a building permit was issued for the painting. I did receive subsequently an email from Lorraine Tappan indicating, and I don't know who Lorraine Tappan is, but it's somebody in the city,
Okay.
that they were trying to work with the Uribes on the color of their house, and they were going to be meeting with them today. So I don't know if the meeting occurred, and after I'm finished with my testimony, maybe Mr. Uribe could indicate whether he met with somebody from the Building and Zoning Department to further discuss the color of the house. My guess is, there is a paint palette of approved paint colors for the city, and when you submit a paint application, the city people in the zoning or the building department review the color samples that are submitted for the base color and trim colors, and if they are part of the approved paint color palette, then they will approve the permit. There is no cost for the permit. It is free for residential property owners. So at this point, seeing that there was no paint permit issued, I had no choice other than to bring the case forward for your review at this time. And that concludes my testimony.
Okay. Sir?
Yes, on my defense, I let Mr. Alan Graham know that we did apply for the permit.
Mm-hmm.
It was right after he notified me that there was a violation.
Okay.
And we went to Building and Zoning, and the person who we spoke with said that the application was not going to be approved.
Okay.
Without even reviewing it,
Okay.
just by showing them the colors. They told us we have to go to talk to community and development, and we did go to community and development. We spoke with a couple of people there. They told us that the colors were pretty. They told us that there wouldn't be a problem, that we have to submit an application, and they were gonna review it. When they find out which was the address, they called me and said that there was a complaint from a neighbor or neighbors saying that the colors weren't on the palette. So if I am misunderstood, why would there be a problem when they didn't know there was a call from whoever did call, and they told me that they were going to approve the colors? Later on, my wife and I spoke with the person in charge.
Okay.
And we let her know that we want to apply for the after the fact permit.
Right.
And it's been in the process for like almost 3 weeks.
Mm.
It's not that we never try to apply for the permit. And as a matter of fact, when Mr. Allen gave us the notice, this is the first thing that we did. We came to the city, spent hours waiting, took the number, and nothing got resolved. And until today that we met with Ms. Lorraine Tappan, we've been with the same argument of showing her proofs that there are other homes with the same color, same tone, and nothing is happening to them. So I don't understand what's the issue. This, we actually got, it started already. So it's not under our knowledge not to comply with code enforcement. On the contrary, we have always tried to comply with code enforcement.
Okay. So where are we now? I'm a little
They're
confused
reviewing the
about-
colors again.
Okay, so they're reviewing the colors.
Yeah.
And he says that he has submitted an application 3 weeks ago.
Sir, can I see what you're referring to? Your application or your paperwork, whatever that is?
Building and Zoning didn't want to pass it. They said it.
No, I understand, but can I see what you're referring to?
No, this is a notice to appear from
Oh,
Mr.
okay.
Allen.
So you submitted an application
Yeah.
with Building and Zoning,
Correct.
and they rejected it?
They said I have to go and speak with community and development about the color approval.
Okay, and so they've not yet approved your color? Or they said they
No,
would
they
not
said that
approve?
they have to review it.
They have to review it.
There's a commission that approves the colors. So I don't know.
And what's the next step that they said that you have to go through?
We are going to meet with the planning manager on Tuesday at 10 in the morning, and we're going to speak about the colors. Because if they don't want to approve it, obviously we will have to go for the next step.
Right, and repaint. Okay.
Your Honor, I know, I'm not going to try to guess what the city attorney is going to recommend, but I would recommend we table this case to give Mr. Uribe opportunity to continue to meet
Right.
with city officials to resolve the issue of the paint color. And I have no objection to bringing this back, table it for a month and bring it back if necessary.
Exactly. Okay, sir. So let's table it. You can continue to meet with the city and see whether or not they will approve it. If they're not going to approve it, then they will tell you to go through the process of resubmitting a permit so that they can approve the color palette. And to the
Right.
extent that they do, keep Mr. Allen, Mr. Graham informed as to your communication with the city and where we are. Otherwise, I will see you back here in 30 days.
Okay.
That will be April 2nd.
Just for the record, the pictures shown by Mr. Allen, Mr. Graham, they are actually kind of dark.
Okay.
Thank you. If they were like significant proofs to show the color of the house, that's not significant.
Mm-hmm.
So unfortunately, I wouldn't even take that as evidence completely. It is my property because it is the structure of the house,
Right.
but the colors are not really well displayed.
Okay.
Okay?
Okay. All
Thank you
right,
so much.
sir. Thank you. Mhm.
Thank you, Your Honor.
Okay. There's no one else here. I am sure the city attorney would love to know that she can leave. You're excused. Okay. Oh, she's our interpreter?
Yeah.
Oh, wonderful. Okay. Pleasure to meet you.
Thank you.
These
Okay,
are,
what is your name?
Terry Aquino.
Okay, great. All right, so we'll see you in next month. Thank you.
Hello.
Oh, okay.
Yes.
You are our interpreter as well, sir? Okay, what is your name?
How are you?
Okay, pleasure to meet you, sir. Thank you.
Yeah, actually, can I, well, you know what, let me call you back in like 3 minutes. No more than 3 minutes. I'm just about to walk out of the meeting.
Yes, honey, you
All right.
can leave too. Thank you.
Wolfpack.
Okay, no problem. You sure you don't want to stay with us? Huh?
Who's you talking to? I'm actually not talking to you.
Talking to him. He's the one, he only has one? Okay. We just want to keep you around a little longer, that's all. So go ahead and start. I'm ready.
Item number 28, Ricardo Deliana, McFarland, Officer Edmund Fitzel, case number CEFAW 2013-00066.
Edmund Fitzel, City of North Miami Code Enforcement Officer. This property was originally sent a letter of violation on November 23rd, 2013. It was cited under Section 29-5901J to maintain fences and walls and to properly keep them painted. This property was posted with notice to appear on February 20th. On the same day, the property was posted with a notice to appear and affidavit was filed. Today, I tried to contact the property owner to no avail. I had two phone numbers. One was disconnected. As of today, the wrought iron fence in the front of the property has not been painted. Would you like to see the photos?
Yes, please. So what exactly is on it? Is it paint? The fences?
The letter on the other side will explain that all the fences need to be maintained and painted. The walls, all our fences need to be maintained and painted.
And you said notice to appear was posted and mailed?
Yes, ma'am. February 20th.
All right. Based on the unrebutted testimony of the code enforcement officer, I find that the violation still exists. I find given proper notice, the homeowners have failed to appear. I hereby impose a daily fine amount of $25 per day with an abatement date of April 1st, 2014.
Thank you. Have a good evening.
Thank you, sir. Have a good evening.
Case, item number 23, Orestes de la Rosa, Vidalyn Christie is the officer. Case number CEFAW 2013-00058.
Vidalyn Christie, Code Compliance. This is a case that was previously heard. Notice to appear or order to comply was posted at the property, and notice to appear also posted at the property. Certified mail was sent out to the property owner, was returned, not signed. I inspected the property today, and there has been no compliance. I do have current pictures for the record if you wish to see.
Yes, please. Which item did you call?
Item number 23, Orestes de la Rosa.
Okay, 'cause I was reviewing item number 3. Okay. All right, so this is in the same condition when you took these photographs today?
Yes,
Okay.
absolutely. That was the pictures from today. Absolutely nothing has changed. The property owner has not been back to the property.
All right. Thank you. Based on the unrebutted testimony of the code enforcement officer, I find that the violations still exist, and given proper notice, the homeowner has failed to appear. Therefore, the daily fine amount of $100 is hereby ratified.
Item number 3, Antiola Austin, Officer Vidalyn Christie, CEBMP 2013-00081.
Vidalyn Christie, Code Compliance. The property was posted with the order to comply, also notice to appear, and a review of the property today, as well as the permit records, shows no permit application or demolition permits, and the property remains the same.
Photos? And this is in addition to?
Yes, this is in regards to the illegal addition on that side of the property that's too close to the property line
Okay.
that
right.
was not granted permits.
I remember this case. Okay, and what did you tell me about notice?
The notice to appear, the notice or the order to comply was posted at the property. Notice to appear for this hearing was also posted. Certified mail sent out and returned.
All right. Based on the unrebutted testimony of the code enforcement officer, I find that given proper notice, the owner has failed to appear. I find that the violations still exist. I hereby ratify the daily fine amount of $50.
Item number 13, Isaac Garcia, Officer Alan Graham, case number CEJNK 2014-00003.
Again, Alan Graham, North Miami Police Department Code Enforcement. I have been sworn. Your Honor, the property owner is not present on this particular case. Notice to appear for this evening's hearing was posted at the property on February 21st, 2014 at 12:46 as evidenced by affidavit of service, which I present.
Thank you. Posted on 2/21/14. All right, thank you.
Your Honor, on January 24th, I cited the property at 2001 Northeast 122nd Road for a violation of City Ordinance Section 10-19, junk on the property. I noticed that there was some construction material on the ground on the northeast side of the house. The property owner is Isaac Garcia, as evidenced by the Miami-Dade County property records. Mr. Garcia purchased the property in February 2012. I do have the Miami-Dade County printout if you need to review it. I did take photos and go by the property again. I went by the property yesterday, March 4th, and took photos of the house and the construction material that is on the side of the house. And I introduced this photo array of 3 photos into evidence at this time.
Ooh. Okay. All right, and these photographs were taken today? Okay, yesterday, March 4th, 2014. Okay, lots of debris, and what do we have here? Are these construction materials?
Yes, it's metal studs for walls
Okay,
or for ceiling material.
all right.
The top photo shows that around the outside air conditioning handlers, there are pieces of concrete block and other concrete type material, and also that there are some metal, it looks like metal shutters and other concrete material also on the side of the house. So that's what it looks like. Those are shutters that were on the windows, it's possible, or interior materials. I've had no contact with Mr. Garcia or any other person representing the property owner. And having no such contact and having cited the property in January, I set this case to come before you. This is a new case. There are no further, this is not a repeat violation. It looks like the property was purchased and they've been doing some remodeling or construction work. The city is seeking an adjudication as a new case and a reasonable abatement date to bring this into compliance.
Based on the unrebutted testimony of the code enforcement officer, I find that the violation exists. I find that given proper notice, the homeowner has failed to appear. I will impose a daily fine amount of $50 with an abatement date of April 1st, 2014.
Thank you.
Item number 25, Rachel Reeves. Alan Graham is the officer. Case number CEPOF 2014-00001.
Again, for the record, Alan Graham, North Miami Police Department, Code Enforcement Unit. This is a case against Rachel Reeves. I did post the property with a notice to appear. I posted the property on February 21st, 2014 at 12:32 p.m. as evidenced by a completed affidavit of service for such.
Thank you. Reviewing affidavit of service. Property was posted on 2/21/2014. Thank you.
Your Honor, on February 15th, I inspected the property at 2082 Northeast 120 Road. The property is owned by Rachel Reeves. Ownership determined by a check of the Dade County property records. Ms. Reeves purchased the property in January 1990. I do have the printout of the Dade County property record should you care to review it. I cited the property for a repeat violation of the POF violation, which is to secure the access to the swimming pool to prevent trespassers or anybody from accidentally going onto the property and falling in the pool. As I said, this is a repeat case. I determined that by reviewing the date of the city's property records, and that I found in reviewing that back on September 7, 2011, a similar case was brought before the magistrate, and at the time the property owner was absent at that hearing, but they were fined the code enforcement board fined the property owner $500 a day as a fine plus court costs. This was under case CEPOF 2011-00010, and I will present this as evidence that this was one of the original cases, and therefore my case becomes a repeat since this was adjudicated and a fine imposed.
Thank you. And I'm just curious as to what the outcome was, and if they had put up a gate and then took it down?
Well, what happened is there was a gate. The gate was propped open, and at one point the gate was completely on the ground. I was at the property, and this was on, I'm trying to see why I took this one. This is the date of the violation. I did take pictures, which would have been February 15th, and I also marked that at this time. I do recall I did take the photo myself, and will introduce that into evidence at the time, showing the status of the gate when I viewed the violation on February 15th.
Okay. All right, and these photographs were taken back in February
Yes, now
15, 2014?
the gate is on the west side of the house. There's an east side and a west side access to the backyard, which would get a person access to the swimming pool and the hot tub area. I did go by the property on March 4th, yesterday, and there was somebody at the property, and they allowed me access to view the gate. The gate was secured at the time. Now, seeing that this is a repeat violation, and by city code and state law, we have the ability to bring it before the special magistrate for the magistrate to consider imposing a fine from the date, since it's a repeat case, from the date I initially viewed the violation on February 15th until it was brought into compliance on March 4th. So the violation was out of compliance for 17 days. So we're bringing the case before you at this time for you to make a decision if you're going to impose a fine for the 17 days it was out of compliance. That's entirely your decision.
All right, and are you saying you've been back from February 15th through March 4th? Have you made any trip to the property to ensure that the gate was still, what is it?
Secured.
Right.
The obligation is to the property owner to notify us when they bring the violation into compliance. My obligation is to inspect it pre-hearing.
Okay.
And I did my inspections, all my inspections for all the code hearings, the code enforcement hearings for today. All my inspections were done yesterday.
All right. Have you made contact with the property owners?
No, but their representative was on site at the time I did the inspection, and I told him that I now consider this matter closed because the gate is secured.
Okay.
However, it is a repeat violation out of compliance for 17 days. So it's entirely within your discretion to either impose a fine or not.
All right. Based on the testimony unrebutted testimony of the code enforcement officer, and that's why it's imperative that homeowners show up for these hearings. I don't know why they don't. Based on the uncontested testimony of the code enforcement officer, I find that the violation did exist. However, again, based on the officer's testimony, the homeowners have has resolved the issue and bring it to compliance. I'm a little torn about the number of days to impose a fine amount, because I'm not sure whether or not they were actually in non-compliant for 17 days. So I will impose a fine amount for half of that. We'll make it for 8 days. And that's really because they're not here to defend this case, and they were given proper notice, and I want to put that on the record. They were given proper notice, and they have chosen not to show up for this hearing. So therefore, a daily fine amount for a period of 8 days in the amount of $50, since it is a repeat violation, which is far less than what that was imposed on them back in 2011.
So the order is 8 days at $50 per day.
Correct.
Thank you, Your Honor.
Item number 26, Rachel Reeves, Code Officer Alan Graham, case number CEPOM 2014-00009.
I apologize, I was writing.
Item number 26.
Got it. What happened to items number 11?
It was postponed to April.
Okay. I did that, or?
No, we did that.
Okay. All right, I'm ready.
Okay, if you're ready to proceed, we'll move on. This is a companion case to the last case. It's the same property, same owner. Your Honor, on February 21st, 2014 at 12:32 p.m., I posted the property with a notice to appear as evidenced by a completed affidavit of service, which I present at this time.
Thank you. Reviewing affidavit of service. Property was posted on 2/21/2014.
Your Honor, on February 15, 2014, I inspected the property at 2082 Northeast 120th Road. Property is owned by Rachel J. Reeves. Ownership determined by a check of the Dade County property records, which I have here, and it's available for inspection. I cited the property for a repeat violation of the unmaintained swimming pool, a violation of Section 12-4A of City Codes. I indicated on the violation that the corrective measures would be for the swimming pool and spa hot tub areas to be drained immediately, both areas to be covered to prevent accumulation of rainwater and breeding area for mosquitoes. I do have a photograph that to enter into evidence at this time. It's a photo array of 2 photos to show the swimming pool and the hot tub area. The photo was taken on February 15, 2014.
Yes, please. This is breeding ground for mosquitoes.
As you can see, both areas look like science fair experiments.
Yes.
And
That's
they're
disgusting.
pretty ugly. I did note that this is a repeat violation. Again, there was a case cited, and the Code Enforcement Board on September 7, 2011 issued a fine for case CEPOM 2011-00023, in which they found Ms. Reeves guilty of the violation cited at that time, which was to a violation of the water clarity, and the water clarity had to be brought into compliance, and it was not. So the Code Enforcement Board imposed a fine of $500 a day at that time. I'd like to introduce this permit action report that indicates the actions taken by the Code Board.
Is this homesteaded property? Do you know? No. Okay.
This property, in answer to your question, property is not homesteaded. It is vacant and boarded. The property owners live one block over on Northeast 121st Road. And they maintain this property as they can. So, taking into consideration that there was a prior case, adjudicated case, for the same violation, I issued a repeat violation notice. I went by the property yesterday at March 4th again, like I did in the prior case, and met with somebody on the property who allowed me access to the swimming pool area. I viewed the swimming pool and the spa, and they had been emptied and cleaned. So the violation was cured, part of it. I also, in my violation, request that both areas be covered to prevent accumulation of rainwater and breeding area for mosquitoes. That is not part of this city ordinance related to swimming pool and water clarity. However, it was a suggestion. The person who was there said, yeah, they were thinking about how to best do that. So seeing how the swimming pool and spa had been drained of all water and had been cleaned, I decided to bring this case forward for consideration since it was out of compliance for 17 days from February 15th to March 4th. Again, bringing this case, like the last case, to you for your consideration as to whether you wanted to impose a fine or not. I will be signing the property to cover both the pool and the hot tub area as a new case, and I'll cite that at another time under another section of City Code.
All right. Based on the unrebutted testimony of the code enforcement officer, I find that the violation did exist. I find that the homeowners has since cured the violation, and just as I did in the previous case, and since it's the same owners, I will impose a daily fine amount of $50 for a period of 8 days.
Thank you.
Item number 31, Yolanda Concepcion. Alan Graham is the officer. The case number is CEIVY 2014-00017.
Again, for the record, Alan Graham, Code Enforcement, City of North Miami Police Department. I have been sworn. Let me find the affidavit. Your Honor, I do have I have posted the property with a notice to appear. I posted the property on February 21st, 2014 to 2:10 p.m. Notice of violation, and subsequently a notice to appear for the hearing had been mailed out and returned to us as return to sender, not deliverable, unable to forward. The house is vacant, but I do have the affidavit of posting, which I'd like to present at this time.
Okay, reviewing affidavit of service. Property was posted on 2/21/14. Thank you.
Your Honor, on January 21st, 2014, I did an inspection of the property at 1900 Keystone Boulevard. The property is owned by Yolanda M. Concepcion. Ownership determined by a check of the Dade County property records. The property was purchased by Ms. Concepcion on June 2014. I do have the property record here if you care to review it. I cited the property for under Section 10-19A for inoperable vehicles. The property owner has several vehicles on the property that are covered with makeshift and some commercial grade car covers. A total of 4 vehicles are parked there that do not seem to be operable at all. And I've had numerous complaints from city residents as to why the city is allowing these vehicles to remain on the property and making it look like a car lot. So I do have two different photos, one array of 3 photos taken at the property on January 22nd, and one array of 4 photos taken yesterday on March 4th. I'd like to introduce these as evidence to show that there has been no appreciable change at all whatsoever in the condition of the vehicles parked at the property.
Thank you. Okay, I am reviewing the first set of photos that were taken on January 22nd, 2014. And the second set taken on March 4th, 2014. Okay.
Okay, seeing that the mail had been returned with the notice of violation, the notice of hearing had been returned, there's no sign that there's anyone currently at the property, and seeing if nobody has contacted me regarding these vehicles, I've brought the case forward as a new case for adjudication at this time to compel someone who is in control of this property to come forward and demonstrate operability or remove the vehicles from the property. So the city is seeking adjudication at this time.
Does the silver and black Mercedes belong to the property?
Yeah, that's parked on the grass, and that's cited under a separate case for parking on the grass, which
Okay.
is a companion case that I'll bring forward after this case.
All right. Based on the unrebutted testimony of the code enforcement officer and the evidence presented, I find in favor of the city. I find that the violation does exist. I find, given proper notice, the homeowner has failed to appear. I will impose a daily fine amount of $50 per day with an abatement date of April 1st, 2014.
Your Honor, the last case on the agenda, Yolanda Concepcion, Officer Alan Graham, and the case number is CEPFY 2014-00032.
Again, for the record, Alan Graham, Code Compliance Unit of the North Miami Police Department, have been sworn. Your Honor, on February 21st, 2014, at 2:10 p.m., I posted a notice to appear for this evening's hearing at the property address of 1900 Keystone Boulevard. I'll present the affidavit of service at this time for your review.
Affidavit of service, property posted on 2/21/2014. Thank you.
Your Honor, on January 31st, I inspected the property at 1900 Keystone Boulevard. I noticed that there was a silver four-door Mercedes with a bearing Florida tag BCK P29 parked on the grass on the front yard. I indicated that the property owner needed to take corrective measures and remove the vehicle from the grass and park it on a paved surface. There was also a companion civil citation issued to the property owner under case CTPFY 2014-00004. Having not received any compliance under that citation, I issued this companion citation CEPFY 14-0032. On March 4th, I returned to the property and took photos, and noticing that the silver four-door Mercedes had not moved 1 inch and is still parked on the grass. A photo array of 4 photos will show that the grass is now growing up over the tire edge, indicating the vehicle hasn't been moved for some period of time. I'd like to introduce this photo array as evidence at this time.
All right, reviewing photographs that were taken on March 4th, 2014. Thank you.
Your Honor, I've had no contact with Ms. Concepcion or anyone at the property. The property appears to be vacant. Numerous notices and flyers and mail has been accumulating by the door. The vehicle is still in its current place as of today. So I have no choice but to bring this case forward as a new case and request that it be adjudicated this evening.
Based on the unrebutted testimony of the code enforcement officer and the evidence presented, I find that the violation does exist. I find, given proper notice, the homeowner has failed to appear. I find in favor of the city, hereby impose a daily fine amount of $50 per day with an abatement date of April 1st, 2014.
Thank you, Your Honor. That concludes my testimony this evening.
Thank you, Mr. Graham. And you've provided me with orders that needed to be signed. Is it for?
That's from our last hearing. We have to do some amendments to that, the second page.
Okay.
So the attorney asked us to remove the signature line from her, so we need to re-sign it.
I see. Okay, because I usually.
Check them against my notes. I've given them to you twice already because we were having problems with changing the violation on there. Because part of the violation wasn't coming out, we fixed that. And then the city attorney asked us to revise it again and take off her signature. So now this is the third time we're doing this. Okay, I guess after I sign this. I'm gonna take them to my car, because I need a card. That's why I brought them in the box. Should be what?
So we're adjourned. Thank you. Good night.